You're welcome back to the show, and let's start from the court because it's been a very interesting development. And this afternoon, where the Attorney General and other parties in the case have returned for the trial today, the Minority Leader, Kayse Latoforsen, then Deputy Finance Minister, is said to have approved the payment for the procurement of some ambulances, which were later said to be unfit for purpose. On their return today, the court had to first deal with the highly contentious issue of a viral tape of third accused Richard Jakpa. We have lawyer Richard Pinsel on standby to help us navigate all the legal issues happening in court. The first, though, we'll take you live to the courts to bring you my colleague Latif Idus, who's covering the case for us this afternoon as we try to understand what is happening. But before we do so, because we understand that the cross-examination of the third accused Richard Jakpa is still underway, and we'll bring Latif on when that is done. But let's bring in lawyer Kweku Pinsel, who is a private legal practitioner. He's been following this case, and we'll start with the issue, the decision of the court or the ruling of the trial judge admitting the tape in question into evidence. Counsel, you're welcome to the poll. So the judge's decision, did it come to you as a surprise, or, I mean, looking at the reasons adduced by her, this sounds right?
Well, it didn't come to me as a surprise. The judge has a right, or she has to weigh, all the options, and she has to make a decision that to her would ensure that at the end of it all, justice will not only be delivered, but be seen to be delivered. And I don't have any qualms with her at all about her decision to permit that evidence to come in. But when the evidence comes in, that's the real issue. That's where the real battle starts. There's something in law we call the probative value, how the evidence will have to be evaluated together with all the evidence that comes before the court at the end of the trial. So the real issue is the evidence having come in, of what value is it going to be, of course, for the party who prayed for the evidence to come in. So that's the real issue that will be determined at the end of the trial of this case. So the game starts now.
So, even though the tape has been admitted, you don't think that it may have any bearing on the outcome of this case?
No, I didn't say that. There is something in the law of evidence we call probative value. That's the real value. That was the essence. That evidence that comes in at the end of the day, how is it going to help your case? All kind of evidence come into the courtroom at the end of the trial. But at the end of the trial, the judge has to assess that evidence in the light of all the evidence that have come in before the court. And then each party has a duty to prove something before the court. In the case of the accused persons, certainly every evidence that they bring in is intended to assist their defense. In other words, to get the court to discharge them at the end of the trial. With due respect, I have my own views about the value to be given to this evidence. Personally, given the charges that have been leveled against them and the evidence so far before the court, if you ask me to hazard an opinion, I would say that this evidence that comes before the court, that's personally my view. I'm a lawyer. I'm entitled to express my view about a matter that goes before the court as if I was even prosecuting the matter. But I personally, and please, you may judge me at the end of the trial of this case, whether any view, any opinion that I share is concurred in by the court. The court really need no concur. But the point I'm making is that whether the court arrives at some other conclusion, that is all that I need to say. That the evidence that they have brought in against the charge that has been preferred against them in court, personally, I have a difficulty. But I don't pretend I know everything. But I'm saying that I personally have a difficulty when you've been charged with the serious offenses that they've been charged with. When you bring in the evidence that the Attorney General tried to speak to you outside the court, I wouldn't know. There's something that I may not know, so I don't want to pretend. So let's see how this thing will run, in the court, together with every evidence that comes before the court. That's my view that I would like to express on this matter.
So, counsel, let me quote here the reasons, adduced by the judge. According to her, the reasons for admitting the recording during the mistrial application on June 6, 2024 still applied. She noted that the pen drive containing the recording has been admitted in the interest of fairness, since any electronic evidence by the prosecution would have been allowed.
Yeah, that's the judge's view. That is for purposes of admitting the evidence. But when the evidence comes in, when evidence comes before the court, it's to assist the court for the court to make a judgment. And what the court does is to assess the value, the probative value. That is to say, everybody, if you've been charged with an offense, your duty is to demonstrate that you are not guilty of the offense. The duty of the prosecution is to prove beyond reasonable doubt that the person is guilty of the offense. The ingredient of the offense is specified by law, what the prosecution needs to prove for purposes of demonstrating that the person is guilty. So when this evidence comes in, I don't know how the defense team is going to use it to demonstrate that the clients were not guilty. The allegation that the Attorney General tried to get them outside court to try to intimidate or try to coerce or try to sway them to do something, how does it assist the defense team to demonstrate to the court that they are not guilty of the offense that before the court? That is the real issue. As for the judge, what she has to do today is whether, in line with the rules of evidence, it is proper to admit the evidence without putting a value on it. It's not the judge's duty at this stage to weigh how that evidence is going to assist the case one way or the other. But having regard to everything that has transpired, whether it is proper for her to accept the evidence before her court and for her to use that evidence in the light of all the evidence in her assessment of the party's case before the court. That is all what this business today is about. In other words, so far, some evidence already before the court. Now that this thing has also come in, all will come into the pot. At the end of the trial judge's duty is to weigh all the evidence in the light of the matter before the court. That is to say that the prosecution's case before the court, and to determine whether the prosecution has succeeded in establishing that the accused persons are guilty of the offense that they've been charged. And like I said, once this evidence comes in, if I understand the evidence very well, it is to show that outside the court, the Attorney General has made some conversation or some discussions with accused persons, in which it is alleged that he has said that they were not really guilty. At the end of the day, it's not what the Attorney General said that was going to influence the court. It is the evidence that will come before the court, including the evidence that the court has admitted today, which shows the conversation that has gone on before, between the Attorney General and the third accused person.
Right.
And therefore, like I said, I repeat myself that it is at the end of this trial that the judge would have to weigh all the evidence, including the evidence today. The question the judge has to determine at the end of the trial is whether, in the light of the law, in the light of the evidence, all the evidence, including what was admitted today, whether the accused persons are guilty of the offense for which they have been charged. That's all that the judge has to do. And he will do the weighing, she will do the assessment and come to that conclusion. So nothing really strange, nothing really new has happened. What happened today is something that happens in our courtroom all the time. And the judge will have the burden, or not the burden, the duty at the end of the day of assessing all the evidence in order to come to a conclusion one way or the other. Very simple.
Right.
That's the way I see it.
Counsel, help us with some education here, and for those who are not lawyers like yourself. So, this tape was the foundation upon which lawyers for Jakpa and, of course, Dr. Kesela Toforsem filed those applications before the court, and asking that the court dismiss the case entirely. And they premise it on the content of this tape, alleging improper conduct of the Attorney General. The judge, after listening to it 10 times, came to a conclusion that it was not sufficient for her to dismiss the case, saying that from what she listened to, the Attorney General, is not heard anywhere sort of coaching the third accused to say certain things in court. And for that reason, those applications were dismissed. Same judge today says that I have to admit the same recording that formed the basis for the applications that were dismissed, saying that it should stand. Educators, is there inconsistency here?
There is no inconsistency. Let me put it this way. At the time that those applications that were heard and determined last week were brought to with a view that the suit or the trial will be terminated in that point in time. In other words, the applications that were brought were to compel or to pray the judge that having regard to this type of evidence that before the court, there's every reason for you to terminate the trial. The trial, you need not be concerned with the trial. That's an early stage. That's the procedure that they wanted to adopt. The judge did not accept the argument. Today's proceeding is intended to let the evidence come in as part of the entire evidence that the court will consider at the end of the trial. In other words, if the applications that were filed last week had succeeded, there will be no trial by now. The trial or the whole prosecution would have terminated. But the judge having ruled that the trial must proceed, the prosecution's case has already ended, as you know too well. The defense is trying to get this evidence before the court for the purposes of the court using that evidence in the light of all the evidence before the court as part of their prayer to get the court at the end of the trial to throw the case out of court. In other words, to find the accused persons not guilty. So the distinction is between a termination of the trial at that stage that the matter reached last week without the further adduction of evidence, which the judge refused. The judge's case is simply that I will still go on with the trial if you think that this evidence will form part, or rather, if this evidence, if it forms part of your case, will assist you to have the court discharge you, I will consider it at the end of the trial. So that is the matter before the court now. That evidence has now been admitted or accepted by the court to form part of the entire evidence. The trial has not ended. At the end of the trial, the accused persons led by their counsel are going to use this evidence as part of their case to demonstrate to the court that the prosecution has not succeeded in leading sufficient evidence, or the evidence that has come before the court is not sufficient for a conviction of their clients. Of course, the Attorney General will respond, but my point is very simple, that the matter before the court now includes the evidence that the judge last week was put before her, now being used as part of this application today. So the judge would not have the benefit of weighing this evidence in the light of all the evidence that have already come before the court and yet to come before the court, because the accused person, like you said, is already in the witness box and he has not finished tendering or he has not finished giving evidence. So that is how this matter is. There's no inconsistency, there's no contradiction, there is nothing that's untoward. And I think that's the proper way that this matter is proceeding. So when this case has ended, all the evidence, including what has been led today, including what is yet to come, the judge will weigh the evidence. That is all what it means.
But my final question will be, Richard Jakpa is still being cross-examined by his lawyer, Tadio Sorry, about few things that he has said. He talks about when he first met the Attorney General, he provided the date as 16 February 2022. He says that the commencement of the plea bargain arrangement started in 2023, and we had met way before that. He said, I met the AG twice in 2022 at night around 10:30. I requested for the first meeting with Godfrey Adame to explain to him that he was being misled. Godfrey Adame told me I am merely an agent and will be acquitted at the submission of no case. He, Godfrey Adame, requested for documents I had given to Yoko during their investigation when I met him the second time. It goes on and on and on, where he even talks about the fact that he told Godfrey Adame on 26th of March at Yoni Kolendi's house that he would battle the AG and the judiciary to the last drop of his blood because the AG had betrayed him in no case submission when he failed to support him. And he goes on to again say that Godfrey Adame had told him that he wanted to finish the case by the end of May because there cannot be a by-election 6 months before a general election. These are the words of Jakpa being cross-examined by his lawyer, Tade Sorry. Now, we know that the court has given the AG the 18th of June to also cross-examine Jakpa. Now that the AG's name and his personality is involved so much in the testimony of Richard Jakpa, I mean, in the way that it's done in the courtroom, are we going to see the AG take the boss and answer questions, or is simply going to use the opportunity to also cross-examine Jakpa and then find a way to respond to these allegations against his person?
You see, this is not something that we don't see in our court. Sometimes the lawyer with the conduct of the case, you have a witness who is making certain allegations. However the allegations are, they will make the allegations. But there's nothing in law that prevents a lawyer from cross-examining a party merely because that witness is making certain remarks or certain allegations against you personally as a lawyer. Of course, depending on, this is a tactical, let me tell you what, a trial is essentially a tactical matter. Right. I mean, there are many things that you can do as a tactical rule. If you think that the nature of the accusations are such that may require you even to apply to come into the witness box for you to be cross-examined and so forth and so on, you can do that. But we haven't reached there. I recall that last week, the judge delivered what I may call a personal plea to the Attorney General to recuse himself from the trial of this court, the trial of this matter. An advice, like I said, is an advice. The Attorney General has chosen not to accept the judge's invitation. It's not too late.
Even though he was not in court on Tuesday and he's not in court today.
Well, it may be a tactical withdrawal. It may be a tactical withdrawal. Because somebody, an advice is an advice, may take it, may not take it. But in law, if the judge had ruled positively that the Attorney General must not, then that becomes a matter that a decision has been made. In the way that the judge advised, fair enough. I personally have delivered a view that the Attorney General may or may not. And there's nothing in law that will stop him. But good common sense may also prevail. And then if the person that you are cross-examining is constantly attacking you, it may even affect your own posture. It may affect the way you yourself respond to him, and that may mar the conduct of the trial. Don't forget that we are all human beings. We are liable in all kinds of situations to behave in ways that are unpredicted. That is possibly what the judge may have seen with her legal eyes and giving the advice. So if the Attorney General has not been coming to court, maybe he's taking the judge's advice, which is not a legal advice anyway, but it's common sense and it's what you yourself think is right to do. But like you said, if you have a witness in the box who is constantly making references to you and talking about things, I may not think that it is tactically wise for you to be in a box and be not in a box. We cross-examine the same person. It may affect you one way or the other, and it may take off the shine of what you are doing. So therefore, if the AG has recused himself, maybe not formally, by not attending court, he's got enough lawyers. Let's not pretend that the whole of the prosecution of every case in Ghana depends on Attorney General personally. Right. He's got enough able assistance. So that's where my comment that I'll try to make on this particular aspect of the matter. I mean, I do not know whether that's a sufficient response to your inquiry.
Of course, I get you, and I'm so grateful for your time this afternoon. Lawyer Kweku Pento is a private legal practitioner, providing some perspective to the decision of the court today. And of course, the cross-examination of Richard Jakpa, the third accused in this matter, is still ongoing. Let me share with you some of the things that have so far come up. Now, he says during cross-examination, which is still ongoing by his lawyer, Tade Sorry, that claims that the ambulance were not fit for purpose are very mischievous, and it was orchestrated allegation to sabotage the ambulance project when it originated from the previous government. He goes on to say that he went to see Kweku Agyeman-Manu, who was then the Minister for Health, at a point, and showed him letters from Alex Sebefia, a former Minister of Health, in a bid to impress upon him to clear the accessories for the ambulance which were at the port because the contract implementation problems had been resolved and were captured in the letter. According to Richard Jakpa, Agyeman-Manu told me, Richard Jakpa, in my face that MPP headquarters are taking over the ambulance case to give fresh contract to party businessmen to enrich themselves. This is Richard Jakpa telling the court. It says government of Ghana has refused to clear the ambulance accessories at the port for political convenience. Big C is ready to install the accessories, carry out training for paramedics, and hand over the ambulance to government for it to use once the accessories are cleared at the port. And then, as part of the contract, clearance of the accessories would have to be done by government of Ghana as captured in clause 3. Big C has honored clause 1 of the addendum, but government of Ghana has refused to honor clause 3. Now, we'll take you to the court when the cross-examination is over, and we can get more from our correspondent, Latif Idris, who is in court covering this particular matter. I will say in the court, but I will take you to the Upper West region, where 8 members of the secessionist group, Western Togoland Liberation Front, have been sentenced to a combined prison term of 306 months, that's 25 years. They were arrested in 2019 in Tumu, in the Sisala East municipality, accused of forming an unlawful group, summoning and inviting citizens to join the unlawful group. Rafik Salam was in court and now reports.
6 out of the 8 persons who were in court were arrested on December 1, 2019 in Tumu, in the Sisala East municipality, along 2 others, including the 93-year-old Togui Kogu II, and first arraigned before the Wasekud court. They were later remanded into prison custody. The trial, however, began at the Wahai court subsequently and were charged, among others, of belonging to an unlawful organization, summoning and inviting people to be members of the unlawful secessionist Western Togoland Liberation Front. The leader of the alleged secessionist group, and who was the first accused, Ismail Zirako, however, died during the course of the trial. His name was, however, struck out, and the position of the first accused person ceded to the General Secretary of the group, Michael Hofe. Principal State Attorney, Lawyer Said Abdul Shakur, led the prosecution for the state.
They intended to secede from Ghana 5 years ago, and that they wanted audience. They want to immediately inform the police. The police then monitored them up to Tumu, when they went and met the Tumu Koro and his council, and indicated to them that they wanted the Tumu Koro to support them so that they can break away from Ghana and form Western Togoland. So on the basis of that, the police moved on and arrested them at the Tumu Koro's police and brought them to here for trial.
After almost 5 years of the trial at the Wahai court, presided over by Justice Yusuf Asibi, they were found guilty of all the charges. The first accused, Michael Hofe, was sentenced to a concurrent prison term of 48 months, whilst Umbagati Samuel, Omar Abdul Samad, Mohammed Karim, and Kanu Emmanuel will serve 42 months each at the prison. 2 of the accused persons were reported sick and as a result were not in court. The 97-year-old Toby Kugu II and 73-year-old Odeba Innocent. They were handed a concurrent prison term of 24 months each. Reporting for Joy News, Rafik Salam.
Welcome back to the pause, and of course, we are keeping an eye on what is happening in the court. And the latest information is that lawyers for Dr. Keisi Latofos, Dr. Bamba, has just rounded up a marathon cross-examination of Richard Jakpa. According to, Richard Jakpa, in his closing comments on the matter, said that the Attorney General, Godfrey Dame, these are his words, called me to spy on Animana. This man was the Chief Director of the Ministry of Health. He was one of those being prosecuted. The AG, filed a null prosecution regarding Animana on health grounds. So he's been excused from the trial. But according to Richard Jakpa, the Attorney General called him to spy on him to verify if indeed he was at the hospital. He said, I did the work and replied at 8:48, 23rd November 2023. AG replied at 8:49 and said, thanks. Jakpa tells court as he delves into a WhatsApp chat of the Attorney General. Again, he says the prosecution of Dr. Keisi Latofos is not in the interest of justice by my interaction and the pressure from my extended family and other respected people I know that it was for political convenience and vindictiveness. And so the prosecution at Atuforsen is nothing but a political wish, and that's according to Jakpa, as he rounded up his cross-examination in court. And we are just waiting whether the AG will take their turn now or come at another day. But before going to court today, the minority on Tuesday has served notice that they were not going to sit in the chamber anytime their leader is in court. So what happened today? James Abeji is in Parliament for Joy News, as he joins us. James, so I know that Parliament is yet to sit, but the minority group, are they in the House waiting for the bell to be rung for them to go to the chamber, or they are in court in solidarity with their minority leader, with the minority leader?
Yes, Elton. So the Parliament actually is, we are still expecting to see whether they will be sitting, but as we speak, the House has not been called to sitting yet. Now, in the morning, the Speaker performed an important duty where he launched the Speaker's Cup, the football tournament that will be coming on next month. And at that meeting, there was supposed to be the minority leadership as well as the majority leadership led by the two leaders. Now, who are also expected to give some solidarity messages at that meeting. But at that meeting, the three first important persons of the minority side were not present. The minority leader, Kesala Tuposin, the deputy, as well as the whip of the minority governance, Kwame Abuja. The three of them were absent. They were only represented by the deputy minority whip, Ibrahim Ahmed. Now, that is where we had the indication that the minority want to live up to the expectation of their threat that anytime the House is called and their leader is in court, they will not be able to come to the courts. And that's where I had the interaction with the MP for Bill South, Clement Jakpa, who tells me that, in fact, if Parliament were to be called into session as at 10 a.m. as had been planned, they would not be able to go onto the floor of Parliament. And so that threat or that decision to boycott Parliament is still in session as we speak. Now, we're just speaking that the court has actually ruled on the issue to admit the tape in court, as you just mentioned now. But I haven't seen the minority leader nor his deputy and then the minority whip anywhere around Parliament.
What is holding the House from sitting? Right, so, all right, so let me take you live to the court now and bring in Latif, who is speaking to the Deputy Attorney General.
And beyond, Tuesday and beyond, you get the full story, so don't worry.
What do you make of his testimony?
He has given his evidence in chief, that's his case. But if you come to court and state your case, it doesn't mean that you made your case. I just want to rest there. We are going to examine him. I don't really, you make your own judgment.
Do you find it credible, the evidence?
Whether it's credible or not credible. He has given his evidence, and I don't want to prejudge us before the court. That's his case. We also confront him with our case, and the court will make a decision out of it.
But are you surprised with the kind of things that he's been saying?
I will not say, because already something in the audios that we've heard, so it's not something new.
He made a point that the AG is urging him to get Atuforsen to be jailed for at least 1 month.
I don't want to comment because you see, it's a life matter. That's evidence in chief, and as counsel, I don't have to comment on specific. But as I said, when we come to court on Tuesday, all those things will be tackled.
But what's your initial reaction on the ruling?
Oh, the judge decided to make a ruling, and that's how the law works. Today, the judge said our objections are not something that she was going to take. We take it.
You think you have enough under your sleeves to undo what Richard Jakpa has said to court today?
Rest it there, and wait for our side of the matter, and you'll be marveled. You rested there.
The audio, you didn't want the judge to readmit it into evidence. That has happened. Are you disappointed?
Oh, the judge has given a ruling. That's how the law works. If you think you don't want something to be admitted, you raise an objection. This is the duty of the judge to make a pronouncement of such objections. The judge has done so. That's rule of law.
You didn't want it because you felt it wouldn't do well for your case. How bad or damaging is this, admission of the audio to your case?
Not at all, because this audio is something that you have heard, isn't it? Haven't you heard it? You've heard it. So what is new in it? but it's about procedure. So in terms of the content, we are not managed by that because it's something that is in the public domain. But as to whether you can tender a recorded or secretly recorded audio is something that we wanted to test because that's why we're talking about law, not about public sentiments, whether you are comfortable, you're not comfortable. It's about due process. And the judge says that that's due process. It can be tendered. We are going by it.
He also talked about the WhatsApp chat between himself and the Attorney General. Do you find that to be credible or is something that has been made up?
Whether it's credible or not credible, I said it's a life matter. As a lawyer of at least 22 years standing, I will not conduct my case in the media by saying it's credible, it's not credible. But come to court on Tuesday and hear our side of the matter.
One question that will not run away is the absence of the Attorney General in court. Is it now clear that he's headed to
He reserves the right to be in court. He reserves the right not to be in court. At the time that he wants to be in court, you see him. If he doesn't want to be in court, you also not see him. So it's just normal.
The last time we asked you told us that the department, the Attorney General's department is studying the advice by the sitting judge. Has that been conclusive yet? Reason why he didn't show up in court?
Leave it there. The Attorney General does not prosecute all the cases in our office. If in this particular matter, sometimes he comes, other times he doesn't come. Today he's not in. It doesn't mean that next time he will not be coming. So you leave it there. Tuesday, Wednesday, next month, I'm saying this matter that we started, we are going to prosecute it to its conclusion.
Would the approach of the Attorney General change following this testimony by Richard Jakpa, today's testimony?
What approach? What approach, if you can?
In handling the entire case.
Attorney General, he's vested with the power to prosecute, and if he needs to prosecute...
I'm talking about the department, not Godfrey Yeboah-Damieh. I'm talking about Attorney General's department.
Like, we are people that prosecuting, do our work as officers of the ministry. So for us, we are paid by taxpayer. What approach is going to take? Because the attorneys are paid by the state, they must work because they are being paid. So if they have to come to court to prosecute, they'll come to court and prosecute. So the strategy wouldn't change? There's no strategy. Whether it's a strategy or there's no strategy, we are prosecuting a specific matter. We are looking at the law, looking at the evidence. We don't take our eyes off the ball. If you do that, by the time you realize, you are down. And I think when it comes to prosecution, prosecutors in the AG's office are seasoned prosecutors and their eyes are always on the ball. And this is what we are doing.
One thing that was also clear is that there was no objection. Well, I don't know if that is a practice of all the questions, all the answers that were given. None of them were objected by the Attorney General?
That to be unusual because the witness was undergoing cross-examination. So have that one in mind. He was not being led in evidence in chief. He was undergoing cross-examination. So the answer, you cannot stop to give an answer. He gives an answer. We also have the opportunity to also come and confront him with what side of the matter.
All right. So that's the Deputy Attorney General who has just finished speaking with the media here at the court complex. So Richard Jakpa today has yet again mounted the witness box and has given testimonies, a lot of testimonies, which I would like to run our viewers through here from the court complex. Again, let me start. Richard Jakpa, as usual, appears in court neatly dressed, well-pressed. Today he was in white with gold on the right side of his breast downwards, and he appeared in court and interacted with members who came to solidarize with him, if you like. And there was an outstanding that needed to be cleared by the trial judge, which had to do with the audio recording. The lawyers for Dr. Casey Latofosin had tried to tender into evidence through Richard Jakpa. The court had made a ruling on that. So the ruling of the court is that the audio recording, the 60 minutes audio recording between Richard Jakpa and the Attorney General, Godfrey Yeboah-Damieh, has been readmitted into evidence by the trial judge and the court. So that recording, for the second time, has been admitted into evidence, and it formed the basis and the central part of the cross-examination of Richard Jakpa today. It's been a very lengthy day, a marathon cross-examination, but the highlight is that the audio recording between Richard Jakpa and Attorney General Godfrey Yeboah-Damieh has yet again been admitted into evidence. And so that was cleared, and then Richard Jakpa was made to mount the witness box again which he did. And so these are some of the highlights of what Richard Jakpa said in the witness box. But in her ruling, the trial judge had given reasons why she readmitted the audio recording into evidence. She says, for the same reason and more, that the recording was admitted for the mistrial application, she readmitted the audio into evidence. The reason is that for the same reason she admitted the audio into evidence during her mistrial ruling is the same reason and even more why she has readmitted the audio into evidence. And she also went on to make the justification that in the interest of reciprocity, the pen drive has been admitted because if the prosecution were the ones presenting the electronic evidence, it would have been admitted. So if the prosecution, that is the Attorney General's Department, were the ones tendering into evidence electronic evidence, the court would have accepted it or admitted it. And so for the interest of reciprocity, the court found it or deemed it fit to again readmit the audio recording into evidence. Now, so then came in Richard Jakpa, who mounted the witness box, and these are some of the highlights of what he said. He said that he met Godfred Yeboah-Dame for the first time on the 16th of February 2022, even before the plea bargain was initiated. He met Godfred Yeboah-Dame for the first time on the 16th of February 2022, even before plea bargain was initiated. And so he also said that he met Godfred Yeboah-Dame twice in 2022, all at night from 10:30 onwards. So he never met Godfred Yeboah-Dame before 10 p.m. It has always been somewhere around 10:30 to 11 p.m. And he requested for the first meeting. So the first meeting between Richard Jakpa and Godfred Yeboah-Dame, according to Richard Jakpa, he was the one who initiated that meeting between the two of them. And when he met Godfred Yeboah-Dame, he told him that he is merely an agent and will be acquitted and during the submission of no case. So this was the promise. According to Richard Jakpa, who was giving testimony today, he said that Godfred Yeboah-Dame had told him that he was merely an agent and that he will be discharged and acquitted at the submission of no case. So this was an assurance he said he was given by the Attorney General, Godfred Yeboah-Dame. And when they met, according to Richard Jakpa, Godfred Yeboah-Dame requested for documents that Richard Jakpa had given to Yoko during their own investigations into the matter. That was the second meeting between Richard Jakpa and Godfred Yeboah-Dame. According to Richard Jakpa, that when they met for the second time, the Attorney General was given documents that Richard Jakpa had given to Yoko during Yoko's own investigations into the matter. Then he delved into the WhatsApp chat between himself and Godfred Yeboah-Dame, and that which was captured in Exhibit 10 for Dr. Kesilato Forcing. He said the Attorney General made it clear to him that he will be acquitted at the no case stage of the ongoing trial. At the second meeting in July, he told me that everybody knows that his target is A1. I'm quoting what Richard Jakpa told the court, that at the second meeting in July, he told me, and he here is referencing the Attorney General, Godfred Yeboah-Dame, told me that everybody knows that his target is Dr. Kesilato Forcing and not me, Richard Jakpa. And he said he believed the Attorney General, who told him he will be discharged at the no-case level, only to be disappointed because the Attorney General didn't come through for him when it mattered most. He also mentioned that during his meeting, Godfred Yeboah-Dame, he showed some letters from the Ministry of Health signed by the then minister. So this was a meeting between Richard Jakpa and the former health minister, Ajuma Menu, during which, according to Richard Jakpa, he showed him some letters from the Ministry of Health signed by the then Minister Alex Segbefia and also from Big C to explain to him that all disputes have been resolved and the only outstanding was for the Ministry of Health to implement the addendum to save the government from any debt, and that there was no financial loss by anyone except his government referencing Ajima Menu's government, which is the current administration, and that there was no financial loss by anyone except for his government. That's from 2017, that has refused to implement the addendum from the previous government. He said he told Ajima Menu that if there was any financial loss at the time, then it was that which was committed by this administration. Per the contract, according to Richard Jakpa, the letter of credit was supposed to have been established immediately upon the signing of the contract, but BOG reneged and breached that contract. This is also instructive that Richard Jakpa essentially is saying that the government of Ghana breached the contract that was signed between Big C and the government of Ghana. And so he's leveling that against the administration, that they breached that particular contract that was signed between Big C and the government of Ghana. Then came the state in which the ambulances were brought into Ghana. According to Richard Jakpa, the ambulances in the state they were brought into Ghana were not supposed to be used at the time they were brought in, and that they were supposed to be parked somewhere safely under warranty, waiting for the arrival of accessories that has been shipped into Ghana. According to Richard Jakpa, these accessories he made reference to are still parked at the port and has not been cleared by the government, which was captured in the contract that the government of Ghana, as part of the contract, had to clear these accessories from the port. It wasn't the responsibility of Big C or Jakpa to clear these accessories. It was clearly stated in the contract that the government of Ghana had to clear the accessories to be fitted into the ambulances to make them complete. Then from there, they would be used as ambulances for the Republic of Ghana. That aspect of the contract, according to Richard Jakpa, has not yet been fulfilled by the government of Ghana. And so these accessories are still sitting at the port, and Big C is still waiting and is on standby to install these accessories into the ambulances and then train the paramedics. Then the ambulances will then be handed over to the government of Ghana to be used as ambulances. And so Big C, according to Richard Jakpa, is on standby and waiting for the government of Ghana to clear the accessories, and then they will do their part by installing the accessories and then train the paramedics who will then put the ambulances in use after commissioning by the government of Ghana. Also, the Richard Jakpa then delved into the issue of some of the conversations he had with the Attorney General. But before that, let's talk about the issue of the seal, the security seal at the Ministry of Finance. Now, according to Richard Jakpa, it is years of dealings with the Ministry of Finance. It is only the finance minister that has the authority to use the security seal on letters of credit. Not even the deputy ministers, not even the directors at the ministry have the authority or the clearance to use the security seal on letters of credit. And so for him, Seth Tekpe, who was then the finance minister, is the one who expressly put the seal on the letters of credit with regards to this ambulance procurement, and not Dr. Kesilato Forsen, because for the seal to be, implanted, if you like, on the letters of credit, it has to go through the substantive secretary of the finance minister, who will then go and get clearance or authorization from the Minister of Finance, substantive Minister of Finance, and then the machine that has the security seal will then be brought by the substantive Secretary of the Finance Minister to be implanted on the letters of credit, if you like. And so there is no way under the sun, according to Richard Jakpa, that Dr. Casey Latoforsen would be the one authorizing the implantation, if you like, of the security seal on the letters of credit. And so that is that aspect of the security seal. Then he went on to say that he met the Attorney General at the residence of his cousin, a Supreme Court judge, and that was where some of the engagements on how the Attorney General wanted him, Richard Jakpa, to testify to get Dr. Casey Latoforsen to go to jail. And that is according to Richard Jakpa, that the Attorney General, Godfred Yeboah-Dame, had told him that the motive behind the prosecution is to get Dr. Casey Latoforsen to be jailed at least for a month at Nsawam prisons, so that there could be that window for a by-election to be held in Dr. Casey Latoforsen's constituency. So he needed for the case to be closed at a certain point to make way for the by-election to be held within the constituency. Otherwise, if it goes beyond that, there is no way 6 months before, or less than 6 months before election, there is no way by-election could be held in any parts of this country. So, according to Richard Jakpa, the Attorney General impressed upon him to make sure that he gets the case, he testify in a certain way to get Dr. Casey Latoforsen to be jailed for at least a month to make way for a by-election to be held in his constituency. Then Richard Jakpa said he told or asked the Attorney General that how confident are you that you can win in the central region in that constituency, which is the seat belonging to the NDC. Then, according to Richard Jakpa, the Attorney General told him that the central region and the Fantis are cheap, and that they will pump money, and these are the words of Richard Jakpa, that they will pump money in the constituency and get the Fantis to vote for their candidates in that constituency. And it has been a very lengthy and a marathon cross-examination here, which was rounded up by the lawyers for Casey Latoforsen. At the end, he said, and I'm talking about Richard Jakpa, he said the AG called him to spy on Nimana, who was part of this trial, one of the accused. He was the second accused person, but no longer part of the ongoing trial. He called him to spy on Animana to verify if indeed he was at the hospital. He said he did that work for the Attorney General, even though the Attorney General at that point had already disappointed him when he promised to get him off the hook during the no-case submission. He still went ahead and worked for him. He showed the WhatsApp chats, which had been turned into evidence, that the Attorney General gave him the work at 8:48 in the morning, and he completed and sent him a response. And the AG replied at 8:49 and said, thanks. He said the prosecution of Attorney General, according to Richard Jakpa, was not in the interest of justice by my interaction and the pressure from my extended family and other respected people I know, that it was for, quote, political convenience and vindictiveness. So that is according to Richard Jakpa, that from his interaction with the Attorney General and also the pressure being mounted on him by his extended family, he knows that the prosecution of Dr. Casey Latoforsen is nothing but something that is born out of political convenience and vindictiveness. The prosecution of Dr. Casey Latoforsen, according to Richard Jakpa, when he rounded up his presentation or his testimony in the witness box, he said the prosecution of Dr. Keselato Forson is nothing but a political witch hunt. So essentially, that is what has transpired here at the court here. Richard Jakpa or Dr. Keselato Forson's lawyers have concluded their cross-examination of the third accused, Richard Jakpa, and then the Attorney General took over and then started with just a question about when the trial or actually started here at the court. And so they will continue with their trial on Tuesday when the Attorney General will take turn to now.
So that's Lateef Idris from the Accra High Court, giving us what transpired in the courtroom today. Now, the Attorney General will have his day in court on Tuesday. You have the opportunity to also cross-examine Richard Jakpa, who is the third accused in this ambulance case. Now, there's also a development in Parliament. Both the minority and the majority are getting themselves ready to address the media. I can take you live to Parliament now, where my colleague James Haveji joins us via Zoom. James, so what is this press conference about?
Elton, it's not entirely clear, but the indication we are getting is that it may address the reason why Parliament, as at 4:00 p.m. today, when there was supposed to be a meeting, has still not been called into session. And so that's the indication we are getting. But as I was telling you earlier, three of the leadership of the minority have not been in the premises of Parliament since morning. The minority leader, his deputy, as well as the whip of the minority, they have all not been in Parliament. Now, it is unclear whether it is their absence of today that has delayed sitting for the day, because quite a number of them have been at the Speaker's program. But yesterday, during the proceedings, some important reports were expected to be taken by Parliament, including the financial statement of the Auditor General's department, as well as the tax waivers issues that have been the back and forth of the two political parties. Some of those were supposed to also be taken again in Parliament, but the minority yesterday raised issues about quorum. And so the second deputy speaker who sat in for the speaker had no option than to actually bring proceedings to a close, because the House couldn't get the appropriate numbers to take this report. In fact, in today's order paper, some presentation of papers are also expected to happen, as well as reading of some bills. But in the last 2 days that Parliament has been sitting, it is very difficult to get even half of the House to sit at every point in time. Before the House is called into session, you will see the numbers on the floor. But just after proceedings have begun, at a point you could see only 5 members on a side of the House, either the minority or the majority. And so the issue of quorum has been one of essence in the last 2 days that they have been sitting, just like yesterday when the House had to end without actually doing the actual business that they were supposed to do yesterday. And so the indication is that even today's delay is because the majority themselves may have not been able to get the numbers to pull through, and that is why the delay. But we've just been told that the majority leader, Alexander Aponyo-Marke, is preparing to address the press here in Parliament, and we are looking forward to some explanation as to why the delays have been, sitting has delayed up until about some few minutes after 4 p.m. here, and whether the House will be sitting. If the House will be sitting today, Thursday, what are the reasons for the House not sitting today? So, Elton, that's the situation here. And so I'm sure in some few minutes, the majority leader should be speaking to us to tell us why we are experiencing what we are experiencing, Elton.
So you also have the minority also getting themselves ready for another news conference. Is that the case?
The minority indication is not something that has come out strongly. We've heard that, but not too sure about that. What we are so sure about is that of the majority. Whether they would also, you know how they do it. One side holds the press conference, and then in some few minutes, the other side also comes up with the press conference to either agree or banter what the other side has said. And so that cannot be ruled out entirely, but that will be determined substantively after the press conference of the majority.
But again, the issue about quorum and the standing orders of parliament is quite clear that you need 1/3 of all MPs of parliament to form a quorum to conduct business on the floor. And if you have to take a major decision, at least half of all MPs present must participate in taking that decision. The MPP, they have 137 plus an independent can make it 138. So they have majority in terms of the numbers. In terms of quorum to start business, 1/3, which is around 97. Is it your understanding that even for the MPP that are so desirous of prosecuting government business on the floor, they are simply not available to form quorum for business to take place?
Exactly, Elton. In fact, the 1/3 that is required for Parliament to begin sitting has been provided in the last 2 days. In fact, I can say that it has barely been provided because when you look at the number of empty seats that exist before proceeding begins, you could clearly see that both sides of the House are not able to pull the numbers. But if proceeding begins, you would see quite a number of MPs on the majority side leaving the floor compared to the number of minority. In fact, yesterday when the minority raised Honorable Mutala, if I'm very sure about that, to raise the issue about quorum, to do the business, to take the reports that were supposed to be presented. You clearly see that Honorable Markins, which is the majority leader, the deputy majority leader, and about 2 MPs, about 4 or 5 of them, on the majority side are the only ones present when this report was supposed to be taken. The minority had about 10, 12 or 15 of their members seated, present on the floor of the House. So the question remains why even the majority that is supposed to be executing government business on the floor is not able to put the numbers. Some are of the argument that maybe some of them are on the campaign of the vice president. Some, the campaign season is hitting, and so they are in their constituencies and are not making their ways here. In fact, the minority MP whose office I had just left before joining you to have this conversation also tells me that as at this time that the House is not called into session, he's leaving to his constituency in the Ashanti region. And so he has some important business to attend to constituent in the region. And so he's also leaving. So it tells you that it is the reason could be that they are very much engaged with political activities in their constituency, especially the majority as we have seen in the last 2 days.
All right, James, thank you very much. And we'll come back to you when that press conference is underway. In terms of the members who are not on the floor, I mean, the pictures we've seen from Dr. Bawumia's campaign in Ashanti region, a lot of the MPs followed him there. And so if the MPP is struggling to get the needed numbers to even form a quorum, that should tell you what is happening. So we'll take you live to Parliament when the majority leader is ready to address the media on key national matters, including why they have an objection to the decision taken by the minority that they will boycott proceedings on the floor anytime their leader, Kese Latoforsem, goes to court. But yesterday, the Ghana Statistical Service was in the news yesterday for some reason. They released inflation figures for May, which showed inflation was slowing. Now, many would disagree with that because their reality does not reflect this, with food prices and other commodities shooting up astronomically. So if you are one of those in such confused state, yes, Kofi Aje, with our research there to help us understand. So Kofi, we have data from the Ghana Statistical Service, which is showing a consistent rise in food prices, especially for the last month. Share with us.
Well, so Elton, if you look at the CPI figures, the Consumer Price Index, it's an index, so it does not measure the actual nominal changes in prices. So people should see it as an index. So the Ghana Statistical Service measure the price change over a period of a basket of goods that they believe that consumers buy each month. So the inflation that GSS churns out is not the usual nominal changes that we calculate. So if you see that maybe you are buying bread for, let's say, 15 cedis and now you're buying for 25 cedis, the CPI here will not capture that nominal change, which is huge for you.
Right.
But in their calculation, which is a weighted average and is an index. So people should see it as an index, but not the nominal price changes that we've seen. Then talking about the index, if you look at the trend analysis, for instance, inflation has been on a downward trend at the year-on-year level. Now we are talking about an inflation rate of 23.1%. But it's always interesting when GSS releases these figures. They are what they call the top 20 items that I think I always find it interesting.
That drives inflation.
Inflation. In fact, most of them are food items, and they all have inflation rates above 35%, higher than the headline figure of 23.1%. Now, if you look at a product like garden eggs, its index or its weighted average inflation rate is about 56.3% in the month of May 2024. So I agree with people when they say that it does not truly reflect what I am feeling, but they should also understand the GSS doesn't measure
only food items.
Only food items. So every item that actually finds its way into the basket has a weight. So depending on your weight, you are able to, influence the price change. If your weight is not really huge, you may have a huge nominal change in price, but you cannot really contribute to inflation.
So I mean, the question on the minds of it, if food prices and food is one of the items that they use in measuring the inflation for the month of May. If people are complaining now, we are in June, so maybe in June things may be different. But as far as May, if food prices, and I've heard the argument that says that, I mean, we are now spending more than 40% of our income
on food.
So therefore, how do you explain why inflation is coming down when what people are buying on the streets is actually going up?
Great. So this inflation we are seeing, the downward trajectory, is at the year-on-year level. So it's comparing the CPI of May this year to the CPI of last year. So that will give you the weighted average. It's over a period of 365 days. But if you look at the data on the month-on-month level, then you agree with the people who are saying that things are not moving downwards, but rather
going up.
Prices. Month-on-month level, for 3 consecutive months, we've seen prices change at the month-on-month level. At the food inflation level, in the month of March, it went up by 1%, 2% in April, and 2.7% in May. Consistent. Non-food inflation, 0.7, 1.5, and 3.6. So that will tell you why people are not really resonating with the 23.1%. But they should understand that this is a weighted average over a period of 1 year. And it is an index. It does not really measure the actual nominal price change. But if you go to the markets right now, like we did, with data from SBM Intelligence, who have given us the opportunity to use their data tunnel, you could see that a product or food item like tomatoes, which you could get the small paint rubber container for 75 cedis, now is selling somewhere around 180 cedis.
Yes, in fact, I can bear testimony.
Exactly. Now, even if you want a tomato, you can pay as much as, let's say, 5 cedis or even 6 cedis.
Yes, for one.
If you are lucky, you can get 5 for 20 cedis. These are nominal changes. You don't expect them to find their way into the CPI, change the CPI that significantly. Inflation for tomatoes, for instance, has a weight of 1.2%. So just imagine. It cannot it
can influence the outcome.
So it cannot really determine the actual inflation, the entire inflation, or the national average. But I agree, if you do the analysis on the nominal and the, just between price changes, you could see that something like pepper, the price has gone up. Somewhere around 65 cedis last year, June. Now you need about 220 cedis to buy the same paint container. Onions, one sack was around, I think, 600 or 700 cedis. Now it's about 1,800. So if you look at it on that nominal level, then you agree with the people that prices have really changed. But they should also understand this is an index. It's a weighted average. It does not measure the nominal changes.
So in previous times, food was still one of the main determinants. There was also transportation.
Yeah.
And then there was also issues like second-hand underwear and all those things. So in terms of the figures that we have now for the month of May, what are some of the key factors?
Let me walk you through some of the key. They continue to be the key drivers. But just like I mentioned, Garden Eggs is number one, the top 20 items to look out for. They are not necessarily the key drivers, but they are the top 20 items that had inflation rate above the national average, about 35%. Garden Eggs, 56.3%. Cabbage, 49.2% inflation. Pets and related products, 49.2%. So those who have pets at home,
Right.
you could see that they are
the animal, the way they are feeding them is
exactly. Carrot is around 44.4%. Ready-made clothing for boys, that I agree, 43.1%. Traditional beer, Pito, Pito, inflation is 42.9%. A new car,
Pito.
a new car, the inflation is around, new car, let me check. New car is 42.7%.
Brand new car.
Brand new car, the inflation is...
I'm sure you can trace it to the government.
Exactly. Now, green paper.
Your everything is behind.
Oh yeah. So let's discuss it this way. So I think I was on number 7.
New cars, and I'm sure the government is responsible for this.
Some time ago, they said they were going to ban the importation of.
No, they didn't enforce it.
Oh, I see. So postal services, the inflation rate for the month of May is 42.6%. And let me stress that these are averages, they are index. So if you pick it on a nominal basis, it could be that the price change is even more than what we see.
Okay.
But this helps us to gauge the economy, the mood of the economy, and the temperature in the economy.
So traditional beer, which is Pito,
yes,
people are drinking more. People are drinking more,
yes,
more Pito.
I mean, it could be that the price of the ingredient that goes into the Pito is actually
Appetizer is gin, right? Appetizer is gin.
Yes,
so it doesn't fall into this.
Appetizer is not part of this bracket. Now let's look at it from 8, 9 onwards and see some other products. If you can show the 9 to maybe 11 or 10. Okay. I mean, so there's tomatoes, for instance, inflation rate of 39.7%. Fresh green pepper. I know a lot of people will agree with the green pepper.
Yes.
Because now the price of pepper, I always say, is hotter than the pepper itself. And dried red pepper. Can you imagine we spent close to $3.8 million to import pepper and other pepper products into this country in 2023. New bicycles. Yeah, bicycles are not very expensive.
Yeah, if you go to Abu Abu,
very, very expensive. Now, fresh tomatoes.
Yeah, of course.
Also
39.7%.
We also Ghana spent close to $38 million to import tomatoes into the country. And we understand that most of these vegetables, the cabbage, I was even speaking on the cabbage, for instance. If you go to the Ashanti region, Bosome, there's a town called Adeto where we get a significant component of the cabbage we consume.
Okay.
On one side of the road, there's galamsey. On the other side of the road, there's cultivation of, cabbage. And that's really dangerous. It's also affecting the price. Let's look at it from
from 13 downwards.
So, yes, fresh okra, 39.6%. Imported beer. So the first one we saw was the Pito. Right. Imported beer. It means people are also drinking.
People are really drinking, yeah.
It's a hard economy.
Sweet apple, and of course
38.8%. There's also firewood, which I will agree.
And we are cutting the trees more.
Yes,
we're cutting down the trees.
So
more.
I mean, demand is still there, but supply has also gone down a bit. So definitely will affect the price. Let's look at the last batch of the top 20 items to look out for. The last batch on the screen. Let's look at it from 17 to 20, which definitely include other interesting
women's footwear.
This time around, not underwear, but footwear.
Okay.
37. And I'm sure a lot of women will agree that currently it's difficult buying footwear because it's expensive. And you need, new ones and fresh ones to match your clothes and all of that. But that's 37.7%. Yam, which at the beginning of this year, you could get one tuber for like 15 cedis. Now you need to pay close to 30 cedis to get puna. that price has also, the inflation is 37.4%.
And there's large onions.
And there's also men's haircuts.
In fact, I pay 80 cedis every weekend for haircuts. 80 cedis.
Well, this is where maybe we'll agree, all men will agree that as for this one, I really, really agree that the inflation for men's haircuts has really gone up. I mean, my barber just did renovation. And then he decided to also
adjust the price.
I mean, it's just
where I go is 80 cedis, for a haircut. But looking at it carefully, food items constitute about 60 to 65% of the items that we're selling.
Yes, the top 20
it
items.
Means food is still driving the inflation.
It's still really driving inflation, and just like we said, in the month-on-month level, food inflation is not coming down at the month-on-month level. It's only year-on-year. At the month-on-month level, we are seeing a very sharp climb for food inflation in the last 3 months. Cumulative-wise, we are talking about close to 6 or 5% increment in the CPI and if this is even CPI, we're not even talking about the actual or nominal price change. Okay.
Well, we thank you very much for coming through with the inflation and the factors that drove it to 23. It may have come down, but if you check the factors, food and food items still driving inflation in the country. And now that we are seeing prices even go up more, I wouldn't be surprised if the reporting in June will take us much higher. We'll take a short break and come back, hopefully take you to Parliament for that Majority News Conference. Welcome back to the Pulse here on Joy News. Now, we're still waiting to get that feed and take you live to Parliament. But before we do that, some 900,000 children in Ghana are engaged in some form of child labor. Now, Kofi is still here with me in the studio as we take a look at the data presented by the Ghana Statistical Service. 900,000 children. What kind of job are they involved in?
I mean, Elton, this is actually contained in the GSS, what they call the 2023 Annual Household Income and Expenditure Survey. And that indicates that 1.1 million children who are aged 5 to 17 years are
5 years.
involved. Yes, 5 to 17 years. That's interesting. Are involved in different forms of work in the last quarter of 2024. Now, you asked about this figure on the screen. They're close to 900,000 children who are involved in sort of employment. Not most of all of them are actually involved in paid employment. If you do the breakdown, you see that a majority of them are either on the farms, or they are serving as apprentices or trainees who are not being paid. But there's 900,000 children who are involved in work or employment work is actually huge.
No, but for those who are involved in farm work, I mean, the explanation could be that they are helping their parents do their farming. How does that constitute labor?
I mean, let me actually read some of the interesting findings from the GSS bulletin. It says that more of the children who are involved in different forms of work are males. I mean, 56% of them are males. Now, they say that, you see on your screen, so male 56 and female is 44. So that tells you the gender mix of these 900,000, children that we are talking about. Majority of them, about almost 6 out of 10 are male. I mean, if you do the percentage-wise across each of the gender, and 44% of them are female.
Right.
Let's look at some other interesting findings from the statistics. So if you look at the impact on education, they say that more than 458,000 of these children are not attending school, and that's a bit problematic. It's very problematic.
They are working. They are not going to
attending school. I mean, those who attended school in the past are, just the 458,000 are 389,943, and a whopping 68,500 have
They've never been to school.
Never.
Despite the fact that education is free at the basic level.
Exactly, and even at the senior high school level, most of them are 17 years, so they qualify to be in the senior high school. 68,000 of them are not in any form of education. Now, if you look at the distribution across the urban and the rural, you could see that most of them are in the rural areas because of what I just mentioned at the beginning, that most of them are on the farmlands. 72% of this, close to 900,000 children that we are talking about, are in the rural area. and in the urban area, we are talking about 28%.
28%.
Something interesting in the report about the fact that Ashanti region is leading, and they have almost the biggest component. None of the regions comes close. Ashanti region has more than 13% of the 900,000 that we are talking about. Ashanti region is leading, followed by the Bono region. So the Bono region comes close with 12.2%. The northern region is, 11.9%. Almost all of them are in the middle and in the northern belt of the country. I'm talking about the top three in terms of the children engaged in employment work. Western North follows number 4 with 1.8. There's 1.6 for Greater Accra region, I have for 0.8. Then you could see that the figure begins to dwindle when we look at other regions. In terms of the sectorial division of the child labor that we are looking at the moment, the services sector, previously the agriculture sector used to be a big component, but now the services sector is accounting for more than 91% of the pie.
The kind of work they're doing.
Exactly, and then also the agric is about 4.8% and 3.6% for the industry. So the biggest component or portion of the pie is being consumed by the services sector. If you look at the pie chart on the screen right now, that's it.
Does the data explain why there's such huge number of child labor in the Ashanti region, for example?
Well, it does not really go deep in terms of the reasons. I mean, these are surveys, so usually they use to gauge some of these indicators. But if you look at regions like the Ashanti region, where, farming is predominant in most of the areas, just look at it. Those who are engaged in employment, the types of work that they were involved in terms of those who are engaged in family work, that's the biggest component. So possibly if your father has a farmland and you are working on it, you are working for the family. So that's sort of classified under the family. That's more than 80%. Unpaid apprenticeship, 11.7%. And self-employed. Can you imagine that we have kids between 5 to 17
doing their own
who
jobs.
are self-employed? I wonder what kind of job they are doing to possibly feed themselves or working for somebody. So paid employees, those who are working and getting something out of it, is the smallest component of the pie, 0.5, and other employment is 4.9. So it tells you the majority of this child labor that we are talking about, most of them are engaged in work, but they are not getting
paid for that work. Are there other details in the report?
Well, there are other details, but we'll publish everything on myjawonline.com. So if you go on myjawonline.com, you can get all the details in terms of the child labor statistics that the Ghana Statistical Service has just released.
Okay, thank you very much. And your show is starting tomorrow?
Yes. So
tell us about it.
Yeah, Beyond the Numbers is starting tomorrow, and then Beyond with Winston Taki is purely business. So we are talking about finance, economics, and geopolitics, and then also we are looking at everything business, the local space, and then also international space. So tomorrow is the first edition. The first segment, which is the local bit, we'll be looking at the exchange rate battle. We are asking the very simple question: has the city won the exchange rate battle? We will be interrogating this issue with empirical data, and also we'll go on to the international space where we talk about the cocoa economy, whether the prices that are actually panning out, we are going to benefit from that, close to 10,000.
And tomorrow at 5:30?
Yes, tomorrow at 5:30.
You're enjoying it. Now, before we go, they toiled, suffered a series of defeats, but picked themselves up and prevailed. That's the resilient story of Tuobodom Senior High School. They've lived up to their school's motto: our suffering will never be in vain, to secure their first national slots after many years of attempt. Their qualification to the national tournament, that's the Science and Maths quiz, is one that will be written in the history books of the school. Emmanuel Bright Kweku has more.
Double TSTS, double TSTS, our suffering will never be in vain. Double TSTS.
All right, so if you have heard the name Tuobodom before, well, definitely, if you've even heard the song Yefri Tuobodom, these are the guys from Tuobodom SHS. and they have qualified to the national championship for the very first time, and they tell me they are from the capital town. So how was the feeling when they said you have won the contest?
Oh, I was like I'm in heaven, you know, because I've never made any record like this. Yes, in my life, this is my first record I've set today. So I was so grateful.
So how do you think your parents will take this, setting a record for your school?
My parents, I know that before I even get home, they will call me and be finding out. If I want to tell them, I'll be smiling.
So what does it mean to your school, qualifying? What does it mean?
Our school, the name of our school will be more than it is. Like, we will get more teachers, more things, more books for our school.
So you are sure it will be more than year free Obodom? All right, so says the coordinators, where are you? Anyone to speak with? Let me find out, over the years, how has the challenge been when you come here and then you don't qualify?
You see, it's been very, very tiresome and very, very, you know, we've struggled a lot. We've passed through a lot of issues, a lot of, you know, we train harder and harder and harder just to meet this. In fact, we have toiled a lot, and we have met what we needed to meet long ago. And we are very, very, very happy.
So what does this mean to you, the teachers, and even the school? What does it mean?
It meant a lot. It meant the whole world to us. In fact, the whole school is waiting for us to come. And this is what they promise us. Tuobodom Senior High Technical School, you have toiled a lot. This time around, go and come back with good news and come and meet us.
So what will happen today at school?
In fact, I don't know if our bus
going to try a party for you.
I don't. Party is understatement. I'm even thinking flying with our bus to the school. Yes, party is understatement. And I can assure you that.
But just before you go, I want you to sing the popular song from your area. Ye free Tiobodom. Oh, why would you sing it? You won't sing it. All right, sure. So
today, no.
Oh, okay. All right, sure. So they are hoping that once they've qualified to the national tournament, they'll make a good name for their school. Today's win is actually something that they would write home about. It means a lot to them qualifying to the national tournament. So these are the gentlemen, ladies, and also teachers from Tuobodom Senior High and Technical School. Nobu TSTS. Nobu TSTS.
And English version, our suffering will never be in vain.
Never. Bravo.
So the competition is getting interesting by the day. Watch out for the schools that will qualify for the national tournament. But that's our show for today. For more stories, log on to our website, myjoyonline.com, and we have very interesting stories there for your. Ambulance trial. AG said his target was Dr. Atofors and not me. That's according to Richard Jakpa. And of course, there are so many stories on myjoyonline.com. Just visit there. That's our show, folks, for this exciting Thursday. Tomorrow, Friday, we shall be here with a weekend edition of The Pulse. Until then, whatever you are up to in the hours ahead, I hope it's profitable. My name is Elton Brobe, and this has been The Pulse.